Greetings, everybody. Welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution. I have some special friends here from Washington, D.C., so I want you all to recite our congressional motto for them very precisely. Here we go. This is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Excellent. Didn't they do well? Yes. Beautifully done. What an exciting week it's been at the National Constitution Center. Man, on Monday, we awarded the Liberty Medal to John Lewis, and that was just one of the most, bravo. There are not a lot of constitutional heroes in America, and he is one, and it was an incredible thrill and amazingly moving to be able to honor him, and I'm so glad that you were able to share it. And then on Friday, Constitution Day, we launched our incredible Constitution app. And I think those of you who were here for the opening show saw me plug it, but if you weren't, I'm going to do it again because I want your help in bringing this to everyone in America. It is so exciting. Go to the App Store, not now, listen to what I'm saying, but after the show, go to the App Store, plug in Interactive Constitution, and download this app, which brings together the top liberal and conservative scholars to write about every single clause of the Constitution, describing what they agree about and what they disagree about. It is a constitutional feast. Educate yourself by picking a different clause every day. There are 80 of them. And you can learn from the top scholars exploring areas of agreement and disagreement. Every time I log on, I find a new clause. Here's the export and port preference clause. I really did not know about that one, and you can find out all about its text and history. It is, you know how much Louis Brandeis insisted on the duty of self-education. You all embrace that duty because you're here, and I want you to continue it by exploring the interactive Constitution and sharing it with everyone you know. And then we have this incredible town hall series coming up. Please come to all of it. Timothy Garton-Ash on September 27th, one of the leading European journalists comparing American and European approaches to free speech online. That's going to be thrilling. Hillary Clinton versus Donald Trump, the constitutional stakes on October 11th. Also listen to our We the People podcast every week for the next 8 weeks. We're doing a special constitutional series on the candidates and the Constitution, and you can learn about what they've said and what our liberal and conservative scholars, how they analyze the candidates' positions. Judge David Barron, a program on the future of the Supreme Court under the various candidates. Programs on campus free speech sponsored by PEN, the American Writers Group. An amazing discussion of populism, demagogues, and constitutional democracy, and culminating on Bill of Rights Day, December 15th. So it's going to be an astonishing array of constitutional programming here at the center. I want you to all come and be part of it. And now I have to ask the crucial question, how many people here are members of the National Constitution Center? That's excellent. There are just a very few of you who are not. Please, I hope those people will join. Just go online or go see Rebecca. She's in the back. You can join at any level. The point is not your financial engagement, although that's appreciated, but your commitment to being part of this community of learners who want to spread the word about constitutional education. So thank you for being part of our family. It's now my great pleasure to introduce a really superb program. There are two very important books that have just come out about the Nixon Court and the Burger Court, that transitional period in Supreme Court history when the court is shifting from the liberalism of Warren to the conservatism of Rehnquist. And these fascinating books talk about the cross currents and the deep contributions that that court has made to our current understanding of the Constitution. Linda Greenhouse, known to all of you, is one of America's leading Supreme Court journalists and commentators, an old friend, and we're so honored every time that she graces the Constitution Center by coming here. And Earl Maltz, one of the leading historians in America about the Reconstruction era. I learned so much from him, and his articles have really changed the way Americans think about the 13th, 14th, and 15th Amendments to the Constitution, which we are commemorating as part of our second founding initiative. And this amazing panel will be moderated by Tom Donnelly, our senior fellow for constitutional studies. If you haven't met Tom yet, please introduce yourself. We're so lucky to have him from the Constitutional Accountability Center in DC. He supervises all of our constitutional content and is just a spectacular educator about the Constitution. Please join me in welcoming Linda Greenhouse, Earl Maltz, and Tom Donnelly.
Hello, everyone, and thanks so much for being here. Just a few orders of operation. First, we will have a book sale and signing in the lobby after the program, so please join us for that. Also, we'll be passing around, if you haven't received them yet, note cards. So we will, if you have any questions for the panelists with about 15 or 20 minutes left, I'll turn to those cards and ask them those questions. And finally, if you could just please silence your cell phones if you have not done that already. But just to kick this off, we're talking about the title of the program is The Nixon Court and the Rise of Judicial Conservatism. If you were to ask lawyers about the Nixon Court, and in particular, Warren Burger as Chief Justice, his leadership of the court during this period, they would often say, I think the traditional narrative is that not much happened during these years. There's a famous essay set that's entitled The Burger Court, the Counter-Revolution That Wasn't, which Linda mentions in her book. And so, Linda, can you just talk a little bit about why that narrative took hold and why you and Professor Gratz have chosen to challenge it?
So the narrative that the Burger Court was just a kind of a transitional period between the liberalism of the Warren Court and the conservatism of the Rehnquist Court, I think grew up because Richard Nixon ran against the Warren Court, ran for president against the Warren Court, accusing the court of having been too soft on crime and fomenting the crime wave that was sweeping the country and so on. He took particular aim at the criminal procedure revolution of the Warren Court, Miranda, Gideon, the exclusionary rule, cases like this. And by the end of the Burger Court, none of those cases had been overruled. So people say, okay, nothing happened. What we demonstrate in the book is that in fact, although it's true those cases were not overruled, they were hollowed out. And so they were left standing as a kind of a veneer. But that by the end of, the Burger Court was 1969 to 1986, so by the end of that 17-year period, a lot of, certainly the momentum of the Warren Court, which was toward ever greater equality, had been totally effaced. And the themes were, I don't want to take up too much my time here, but the themes were quite otherwise. But you had to do a little bit of hard looking to discern that. And people have just kind of shrugged and moved on, I think. But it's, our main argument is that what happened in the Burger years and what was prevented from happening, and I know we'll talk about that, really has shaped the constitutional landscape that we're living in today in ways that people are not aware of, but that are very important.
Terrific, and we'll explore some of those issue areas in particular, but Earl, just turning to you, what do you make of the larger narrative of the counter-revolution that wasn't? And maybe if you just want to say a couple of words about Warren Burger himself and why Richard Nixon chose him as Chief Justice.
Well, first with respect to Warren Burger, Burger was an outspoken critic of the Warren Court's criminal procedure cases and was known for that. And that's, I think, why Nixon chose him. With respect to the counter-revolution that wasn't, I think that it's not that scholars think or other people think that nothing happened. It's just that the things happened, unlike the Warren Court, where everything that happened moved the law to the left. The things that happened during the Burger years, things that people would think are quite important, Roe versus Wade, Bakke, the affirmative action cases, the death penalty cases. There's no clear ideological orientation as you move them back and forth. And I think that it's more that there's not that clear ideological orientation rather than that nothing happened. This is the way that I would describe it, but it's just more difficult to describe exactly what did happen in sort of conventional ideological terms.
That makes sense. That makes sense. Now Linda's book covers the breadth of the Burger Court years, so sort of the whole span of it, and talks about many different areas where the law got shifted. But Earl, you focus on one particular term, the 1972 term. So, just as a question, why one term, and why in particular the 1972 term?
Well, since the first year I started law school, but also it was a lot happened during the 1972 term, in some of which actually people didn't realize was happening during the 1972 term that didn't have come to fruition until the following terms, particularly with respect to school desegregation. So that it would be difficult to find a term where there were more sort of politically consequential cases and cases that were also extremely consequential for the development of constitutional doctrine in the 1972 term. So, for example, we had something that people cared a great deal about then, but not now, the obscenity cases. We had the sort of march and then ending of the limits of school desegregation. We had the critical case on sex discrimination, Franiero versus Richardson, which sets the tone for the remainder of cases. We had the financial aid for schools, and of course we had Roe versus Wade, which changed everything in a variety of different ways. So that was the reason that I chose the 72 term, was just that a lot happened. And also the other reason was that normally you don't have these sort of horizontal kind of studies of a particular term. You either have a particular justice, a particular doctrinal area, or like Linda's book, a whole court. And I thought it would be interesting just to study one term, and that was a consequential term.
Excellent. And I mean, another case during that term that we don't study as much in law school anymore, but I've thought is quite emblematic of the shift from the progressive Warren Court to a more conservative Burger Court is the Rodriguez case, which both of you talk about it in some detail in your book. Linda, if you maybe want to tee up that case, explain what's about and why you think people have underestimated its importance over time.
Well, I'm willing to bet that most people in this room don't recognize the name of the case, San Antonio against Rodriguez. But maybe a couple weeks ago you read about the Connecticut court decision that invalidated the school financing method in the state of Connecticut as a matter of state law, as a matter of state constitutional law. People, was that on anybody's screen? So, the question is, what was this doing in state court, for instance, and why is this issue coming to the fore at this time? So San Antonio against Rodriguez was a federal court case that challenged the fundamental basic way that we finance the public schools in this country, that is to say, through the property tax, through district by district wealth in property. And the claim was that it violated the equal protection guarantee for poor districts to have to tax themselves a great deal to try to bring themselves up to some kind of minimal level of education, whereas wealthy districts sitting on a pile of wealthy property and revenue generated by the property tax don't have to do that and start many, many miles ahead. This claim that poverty, relative poverty, stated some kind of constitutional violation was the product of a lot of thought and energy and movement of progressive activists, lawyers, and some judges throughout the 1960s, and the cases like it were in the pipeline, courts around the country. This particular case made its way to the Supreme Court, reached the Supreme Court just as the Nixon Court coalesced with the 4 appointments that Nixon got in his first 3 years in office. And the claim was rejected by a vote of 5-4. And that was the end of the game for that particular way of looking at poverty in America through a constitutional lens. So, when I said it's not only what happened in the Burger years, but things that were prevented from happening, that is certainly one of the major cases.
That's interesting. And Earl, what do you make of the Rodriguez decision? And more importantly, just looking at the composition of the court at the time, what does that decision suggest about the Burger Court, more broadly?
Well, I think that I would put Rodriguez together with a case that was decided actually the year before, Dandridge versus Williams, which had to do with the court's refusal, even before the appointment of Powell and Rehnquist, to constitutionalize the right to welfare. I think, taking Linda's point, that what it symbolized or emblemized, that's not a word, is the courts stepping back from the idea of making real institutional change in the United States. That if you look at there are a number of individual cases, you can compare that to Roe, where they would focus on one particular right, where they were talking about, you're really talking about trying to create a real major social change by talking about discrimination about poverty on the basis of wealth or welfare or things like that. And people like Justice Powell in particular didn't believe that the court should be involved in that kind of institutional change, in addition to the even more conservative members of the court who didn't believe that as well. And so I think that would be, that's an oversimplification, but I think that's the core of why Rodriguez was emblematic of a lot of different things.
No, and both of you talk about how when we think of the Roberts Court today, especially prior to the death of Justice Scalia, we think of it as divided into two ideological sides, conservatives and progressives. Maybe at most we have Justice Kennedy in the middle, and both of you describe a Burger Court where there was perhaps a more dynamic middle, where you have 2 or 3 or even 4 justices that lawyers could argue to given a case, and that might shift to either conservative or progressive results. I mean, Earl, do you want to talk a little bit about how that, who some of those justices in the middle were, and how that shaped the Burger Court's jurisprudence during this time?
Well, the first thing I would say about that is just as an introduction, is that there was sort of a progressive constitutionalism and there was everything else. So that Richard Nixon was appointing people who were everything else, and some of them, Rehnquist in particular, and to a lesser extent Berger, would fit the conservative mold now. But with respect to the middle people, there were, depending on how you count, in the 1972 term, there were 4, and they were 4 very different people. There was Byron White, who I think one of my colleagues aptly described was essentially a Kennedy liberal. That is, that he when he was appointed to the court by Kennedy, the social revolution, too strong a word, but the war on poverty had not yet happened, things like that. And so he tended to be sometimes more extreme right or more extreme left on particular issues. The other 3 justices, Justice Stewart, Justice Blackmun, and Justice Powell, were different in that regard. That Stewart was kind of an Eisenhower Republican. He was appointed by Eisenhower, so he would look like a moderate progressive. And Blackmun, hard to characterize, quite conservative in 72, moves left during the rest of particularly late in the Berger era, but even in 73 becomes famous for writing Roe versus Wade, and also is a moderate on school desegregation. And then there's Justice Powell, who is a classic Southern moderate. So you read, and that there's a lot of Southernness in him, but he's basically a moderate person. And I think in some respects he is emblematic, because you might sort of take on the Burger Court, which I think, I'm not sure is that much different than yours in this regard, Linda's in this regard, is that what you got from the Burger Court was things that the sort of affluent, well-educated Protestant people in the United States believed in. And that's if you look at those people who were in the middle, that's who they were, rather than being committed progressives or committed conservatives like Rehnquist.
Yeah, I mean, maybe that's an occasion. I mean, Earl's mentioned Roe against Wade a couple of times, so I think that's a fair description of what the court was doing in announcing a woman's right to abortion. The court, I mean, Roe against, a lot of people assume Roe against Wade was 5-4. It was 7-2. The 7 included 3 of the Nixon 4 justices, including Chief Justice Berger. And the court in no way thought it was doing anything radical. The court was ratifying the view of the justices' peers in the professions, in the elite of the legal profession, the medical profession, which had been the really propeller for abortion reform in the late 1960s, and ratifying the view of most of the American public, at least as revealed in a Gallup poll, that in the summer of 1972, just before the term began, as the court was closing in on the final iteration of Roe against Wade, asked people, do you believe that abortion should be a question left to a woman and her doctor without the state intervening? And a strong majority of the public across all demographic sectors, including Catholics and including Republicans, about 2/3 of Republicans said, yes, just woman and doctor. So, it's easy from where we sit today, having seen the politics of abortion distort our judicial confirmation process and our domestic politics and so on, that the way it looks today is not the way it looked then, and it's not what the justices thought they were doing.
And Earl, what do you think about that account? Do you generally agree with that framing?
Yes. In general terms, yes. I think that it's so that going back to amplifying Linda's point, that if in the 72 election, Nixon did start to talk about abortion as a way of appealing to the Catholic vote, and George McGovern was famously referred to as the candidate of acid amnesty and abortion.
AAA, right?
AAA. But at the time, it certainly wasn't a core issue that divided the two parties. It became, for a variety of, it became a lightning rod, because both strongly pro-life, first strongly pro-life people and then strongly pro-choice people moved into, divided largely along party lines, although not entirely. And that's how but it was because of Roe that was created, that created that.
No.
Well, all right, we could argue about that. I think that I actually, never mind. But the one thing that I would say about that in that regard, which illustrates that point, is that I wager that most people in this room would not know that the first pro-life candidate for president to run in the primaries was Ellen McCormick, who ran in the Democratic primaries in 1976, which I think demonstrates that both sides were looking for a party to take their position about this, and so.
Or another way of putting it, I mean, you're right, of course, is that the fact that Richard Nixon was advised by his very smart people around him in the 72 election, Kevin Phillips, Pat Buchanan, some names you might recognize, to come out against abortion. That was before Roe, don't forget, but there was abortion reform in the air. Nixon didn't care about abortion one way or the other. He had no position on it. So it was purely strategic on his part. It took a decade of careful cultivation by conservative Republican activists to effect the kind of party realignment that was finally achieved with the rise of Ronald Reagan and the coming together of evangelicals and Catholics who had never historically trusted each other or been allied. The sense was among these folks that abortion could serve as the instrument for the kind of northern strategy, that is to say, peeling away the urban ethnic Catholic voters who were traditional Democrats, that the southern strategy had been so successful at in the Nixon years, that is to say, peeling away the white voters who had traditionally been Democratic. And we're living with this today. And it took, as I say, it took until the very end of the 1970s. If you look at, my favorite example that proves this point is that the first justice named to the court after Roe was John Paul Stevens, named by President Ford to replace William O. Douglas, certainly one of the most liberal people ever to have sat on the Supreme Court. That was in December 1975, so almost 3 years after Roe. He didn't get a single question about abortion in his Senate Judiciary hearing, not a single question. In 1976, the next presidential election cycle, the Republican platform was still a big tent on abortion. Had to be, because most Republicans were still pro-choice. And so it wasn't until the 1980 platform that the Republican Party called for the appointment of judges who would overturn Roe against Wade. It's a fascinating and little understood story, but it's an inherent part of the history that we're talking about.
No, and I mean, what's amazing about both of these books is how they really situate you in this moment in our constitutional history. Some things still reverberate to today, but you can also get a sense of the possibilities or the paths that might have been taken. Another landmark decision by the Burger Court had to do with Richard Nixon himself, and sort of famously, the Burger Court in forcing the president to turn over the tapes effectively ended the Nixon presidency. One interesting argument in your book, Linda, is that people may think of this as weakening the presidency, but in many ways you argue that the Burger Court strengthened the presidency. Can you talk about some of those?
Well, there's so many ironies to the Watergate tapes case. I mean, the biggest irony, of course, being that the court that Nixon created is the court that ended the Nixon presidency. To his great shock, he really didn't think that all four of his appointees would turn on him. But the other irony is that the court acknowledged an executive privilege residing in the presidency that had not been acknowledged before. They just held it in this circumstance. The need for this evidence overcame the privilege, but the fact that the privilege remains waiting to be invoked, in other circumstances is what you're referring to.
Yeah, no, I just thought that was a really interesting observation. Another large issue that the Burger Court struggled with was one that's once again near the top of the news with the Supreme Court in recent terms. That's the death penalty. I wonder what lessons the current court may be able to learn from the Burger Court's experience wrestling with it, if any. Professor Maltz, maybe?
I'll just start with what I think is, the first thing I think picks up on a point that Linda made about the abortion cases, which is that the court, the majority, the 5-justice majority in Furman was the first case where the court imposed, basically they invalidated all existing death penalty laws, but in a case which had 9 opinions. But the court, and I think progressive commentators generally, misjudged the mood of the American people about that, because they said, okay, we'll strike down all existing death penalty laws, and that then none of them will be reenacted. Well, that didn't turn out to work so well. And I think the irony of the death penalty cases is that and among the death penalty laws that were reenacted were those which made the death penalty mandatory for particular things. And I think it's ironic that the person who keeps the thing from being a complete disaster for progressives is Justice Powell, who in Furman was very strong about not imposing any limitations, basically, on the imposition of death penalty. Probably too strong a word, but then 4 years later, in Gregg, in those cases, says you can't have mandatory death penalties. So, I think again this picks up on Linda's point. I think that the moral of the story is that when the court gets too far ahead of public opinion or misreads, does things that are really against public opinion, that there's going to be a backlash that they're going to have to deal with, and it can create a mess. And I think what we've had in the death penalty is a mess. Everybody would agree for the last 40 years, on whichever side of the issue you're on, we've created a mess. So what could the current court learn from that about the death penalty in particular? Yes. I don't think, unless they were going, I think the other thing you could learn is that if you're going to strike at something, you need to strike at it. Because if you leave openings if you leave even apparent openings on A, the death penalty, or B, and again on abortion, the people who are likely to organize and to try to take advantage of every opening that you leave them. And I think that's true on the death penalty. It's been true on the death penalty. I think it's been true on abortion. I think it's true on financing of parochial schools, and I think it's true on affirmative action. So maybe if there's a general lesson to be learned, maybe that's the general lesson to be learned.
Yeah, I mean, I think it's certainly easy in retrospect to say the court got ahead of public opinion on the death penalty. Right now, you might almost say the court is behind public opinion, because public opinion, as manifest by the number of death penalties that are being imposed, very few, the number of executions, I mean, minuscule. I think, a couple dozen a year in this great big country. The number of states that have either legislatively or through their state courts said no to the death penalty, I think it's very foreseeable, depending on what happens in the near-term future with the Supreme Court, that the court will revisit that issue.
The one thing that I would observe about that, one of the things that White in particular focused on in Furman itself was that they were in the same situation with respect to that in 1972. There were very few death executions that were actually carried out in 1972. So, and I think it's also complicated. If the court just says it's completely unconstitutional, then I don't think there would be any huge backlash to that. But if they leave any openings, I think the responses are going to be regional, as they were to Furman itself. You see in states like, I guess, Florida and Texas, where they, and one of the, so that's all I have to say about that.
Excellent. Well, I mean, one of the things that's notable about Nixon as president and candidate is he often used the theme of law and order. And as Earl had said earlier, one of the reasons why Chief Justice Burger was selected to be Chief Justice was to perhaps be lead a law and order court. Of course, the Burger Court didn't overturn many of the Warren Court's landmark cases in this area, and yet there was a major shift to the right in this area of the law. I mean, it takes a bit of parsing, and you do such a great job in your book. Can you give a sense of a few of the areas where, prior to the Burger Court, where the criminal rights, how robust they were, and then how they were restricted? A couple of examples to get the power of the shift.
Well, I'll give one example from the court's last term, a case called Utah against Strife, which may have penetrated to the public because of a powerful dissenting opinion that Justice Sonia Sotomayor wrote, where she quoted James Baldwin, and she quoted from the New Jim Crow and from Ta-Nehisi's book and so on. So this was a case about the exclusionary rule. Warren Burger hated the exclusionary rule, which the Warren Court had made binding on the states. The exclusionary rule that says that the prosecution cannot use illegally obtained evidence against the defendant. So, for instance, in this Utah against Strife case, the police stopped a man who was walking away from what they had some maybe reason to suspect might be a drug house, but the officer who stopped this man had no idea how long the guy had been there or who he was or whatever. He's just walking down the street, goes up to him, stops him, asks for ID, runs the ID through a data check. Turns out that, lo and behold, he's got an unpaid parking ticket. And this is a predicate for the search. The search turns up drugs in his pocket, and arrest, and so on. And he challenges the introduction of this evidence as the fruit of an illegal search, illegal stop. There was no reasonable suspicion to stop him. And the Roberts Court said last spring, well, yes, it was an illegal search, actually. And there is such a thing as the exclusionary rule, but we're not going to apply it here because, really, what's the reason for the exclusionary rule? It's to deter illegal police behavior, and that just doesn't apply in a situation like this, And that really kind of carried out what started happening in the Burger years, which was all kinds of reasons why the exclusionary rule simply was not going to be held to apply. There was an intervening, what the court said in this later case, drawing on Burger Court cases, there was an intervening event, which was the discovery that the guy had an unpaid parking ticket, which, as Justice Sonia Sotomayor pointed out in her dissent, could characterize something like 40% of the American public at any given time. And coming against the background of the controversy over police tactics of stop and frisk and so on. This was really a very potent case, and I think it just kind of brings home exactly what's been going on with the rights of criminal suspects.
Excellent. And so, Earl, there weren't that many important criminal procedure cases in the 1972 term, but looking at the breadth of the Burger Court, do you think Nixon would have been pleased with how much the court shifted in these criminal procedure areas, or what do you think would have been his assessment if you asked him?
I think he would have been moderately displeased, would be my guess. Someplace between moderately displeased and moderately pleased.
This may be, apostasy, but I don't think Nixon cared one way or the other.
I agree with you. He asked me to think.
It was all strategic.
Right, I agree with you. I think presidents like Nixon and George I. Bush cared, I think, primarily about foreign policy, and the rest of it was strategic. So
yeah.
I was trying, but to the extent that addressing the question, so that the one thing that I think I would add to what Linda said about that is that one place where there were, in doctrinal terms, more dramatic shifts or shifting back was in the statutory issue of habeas corpus, which non-law geeks don't focus on much, but are very important because that has to do with access to the courts. And in that area, I think the Burger Court was pretty aggressive in actually attacking some of the doctrinal innovations of the Warren Court, I think particularly in the case in Stone versus Powell and cases like that.
Oh, yeah, I totally agree with it. So, just maybe to elaborate, so habeas corpus is the means by which federal courts have jurisdiction to review the quality of justice that's being meted out by the state courts. And in the Warren Court years, there was great concern about the fairness of particularly the southern state courts to administer justice, without respect to racial discrimination and so on. And so the Warren Court had built up a very robust habeas corpus jurisprudence, which the Burger Court, carried on by the Rehnquist Court and into the Roberts Court, has done its very best to dismantle, aided by Congress with new statutes that curb federal court jurisdiction. But it's, it sounds pretty technical, but really the way it works on the ground is, do we get federal judges who have the ability to take a second look at what's been happening in the state criminal justice systems? And really, that's no longer the case.
Terrific. So thank you so much for your questions. We have a lot of great ones right here. Here's a fairly a general one. We've talked about a few different lines of cases so far, but putting those to the side, can you pick one sort of additional case from the Burger Court that you think had the most impact on us today?
Well, I'll take a crack at that. So I'll talk about race in the schools. Okay, so of course, famously, the Warren Court decided Brown against Board of Education in 1954. By the time the Burger Court comes in 1969, there basically had been no desegregation. And so any court that was going to follow the Warren Court was going to have to make basic choices. What kind of remedies for unconstitutional segregation were going to be acceptable? And the Burger Court said, okay, to busing within a school district. That was the case from Charlotte, North Carolina. But when the issue moved to the north, in a case from Detroit, Milliken against Bradley, the Burger Court said busing is not a legitimate remedy across district lines. And of course, this helped to create, the inner city, mostly minority public school systems ringed by the white suburbs, and, this kind of barrier that that desegregation remedies cannot cross. And that is another case that defines our landscape today.
I would actually I would actually agree with the characterization of as important cases. I would simply observe that the Burger Court, there was nothing in Warren Court jurisprudence which suggested that widespread busing would be an appropriate remedy in the typical northern situation. There was just, they hadn't dealt with anything, and then the latest, there just wasn't. So I would say that the court's record on that was more mixed. I would to say that we had widespread busing in northern cities was a big change, but also it is no doubt true, without any question at all, that the impact for a variety of reasons turned out to, was limited by Milliken 1 in terms of, so that's, I don't think we disagree. I just think that the shades of how I look at it ideologically might be a little different. So I think that's number one.
Excellent. Why do you think Americans know so little about the Burger Court and about the Supreme Court overall?
Well, so the one follows the other, right? That's always been the case, you know. I mean, the court, it's not on television. You know, you have to kind of dig a little to find out what it is that they're actually doing. You know, they don't speak directly to the public. They're not kind of out there. You could see a justice walking down the street and not recognize that person. So the court's never been, you know, it's just rare throughout our history when the court has really sort of grabbed the public imagination. I mean, look at our presidential campaigns. In the 2012 election, when certainly the future of the court was at least theoretically on the table, neither President Obama nor George who was this?
Mitt Romney?
Yeah, Mitt Romney, not George Romney, got a single question in any of the presidential debates about the Supreme Court. You know, I found that really surprising, but on the other hand, I shouldn't have been surprised because that's just the way it is.
I think that actually that what the public knows is the results of high-profile cases. That's what they know. And also they know, and so with respect to the Burger Court, they know the name Roe versus Wade. They know about the death penalty cases, and they know about affirmative action because those are things which continue to have resonance for people and are relatively easy to understand. And I think one of the things that's changed nowadays, is that we have a few more celebrity justices. And I start with, and I'll blame Scalia for that. But in general, I think also the public, for obvious reasons, is a lot more interested in specific results of cases than in the details of judicial reasoning. And this feeds into the issue about things like habeas corpus, right? That they're just not, so they'll know about the death penalty, they won't know about habeas corpus.
I think most people assume Roe against Wade was a Warren Court decision. I don't think most people think of it as a Burger Court decision.
You're probably right.
I don't think most people think about the Burger Court at all. It ended a generation ago. You know, my students weren't born while Warren Burger was Chief Justice, so, you know, it's totally understandable.
God, we're old.
So who was the most important justice on the Burger Court and why?
Lewis Powell.
Lewis Powell.
Yeah. I mean, he was, I wouldn't say he was the Anthony Kennedy of the Burger Court for the reasons that we discussed. It was not 4 + 4 + Lewis Powell in the middle, but he was very influential. He was respected by his colleagues across the board. He worked really hard. He had quite strong views. He was able to project his views. And he was definitely the most important and one of the most he was very interesting for all those reasons. Plus, I'll just add this, he left the public a great set of papers. And Washington and Lee, his alma mater, to whom he gave his Supreme Court and all his personal papers too, has digitized most of them. So if you're interested in any of the cases that we've discussed or interested in Lewis Powell, you can go on the Washington and Lee Library website, Google it, type in Lewis Powell papers, and you'll get them. I did it just yesterday for a totally different project, and it's just a fabulous set of papers, so I give him great credit for doing that.
And my impression is he was consciously keeping, there are a couple places
Oh,
where he's
totally.
consciously keeping, yes, for his place in history. And I would agree on Lewis Powell. I think that basically, largely because he found himself in the middle of most of these. I don't know, but I don't know how, except for the fact that he was off in the swing boat and could therefore influence the writing of opinions. I'm not sure that he actually I'm skeptical about how much justices generally actually persuade one another.
Oh, I agree with that. Yeah.
But so he found himself in the middle, and I agree, he's interesting. Sometimes you read the papers, he sounds like Ashley Wilkes, but
People get the reference to Gone with the Wind, right?
sounds like either a combination of Ashley Wilkes and Rhett Butler, because he had that sort of steel in it as well.
I'm sorry, Lewis Powell as Rhett Butler, that doesn't cut it for me.
I'm talking about the sort of
No, think of something else.
How would Supreme Court history have been different if Nixon lost the 1968 election?
Oh, it would have been hugely different. Because, four vacancies occurred. So,
oh my gosh, I'm sorry.
yeah. So, whoever, it just would have been, it would have been the opposite, let's say.
I wouldn't say it would have been. All right, this is what we would have if Hubert Humphrey had defeated Richard Nixon. We would have a constitutional right to welfare benefits. We would have a requirement that school financing be equalized across districts. We would have no limitations on affirmative action at all. We would have just everything would have been different. We would be having an entirely different conversation. I think that it's hard to imagine. If you look at the way that the Warren Court pushed the boundaries of constitutional law in a progressive direction, and they were just hinting at some other things, if Hubert Humphrey had won the election and had appointed 4 justices, for the next 20 years, those boundaries would have been continued to be pushed to the left, and it's hard to imagine where they would have been.
Well, but I'll just say this, and I'm sure Earl agrees with me that, the court's in constant political dialogue with the rest of society. So had those things happened, there would have been some kind of political response, and it might not have been the political response that progressives would have liked.
That's true.
So just as you can read Richard Nixon's election as in part a public response to the Warren Court, obviously not totally, but a court as activist as you posit would have faced political ramifications in the general society, I'm sure.
My only observation about that is, so we would have had Ronald Reagan 4 years earlier? I mean, no, because by 1980 we get, so.
And this next question actually dovetails, I think, nicely. To what degree was the Burger Court simply following public opinion?
Well, the court always tracks public opinion sooner or later. I don't think it deliberately follows public opinion as an active verb, but inevitably, the court is never too far out of sync with the prevailing views of the country, because the public elects presidents who fill vacancies, and or let's hope they fill vacancies eventually. Try to fill vacancies, and you know, there's a dialectic. So it's not, you know, it's not a put down of the court at all to say the court brings itself, aligns itself ultimately. I guess Robert Dahl pointed this out, a great political scientist, and much more eloquent than the way that I put it. I guess he said the court aligns itself with the, how do you put it, the governing majority, right? And that's, you know, that's just observationally true. Do you agree?
I would phrase it slightly differently. That I would say that there are, again, the court is appointed, the people appointed to the court are establishment, upper class people. That's who they are. And there are within the, there are views that are acceptable and views that are not acceptable within the establishment, upper middle class community, or the establishment, affluent community, well-educated community. And depending upon the precise configuration of the court, they'll be somewhere in there, but that's, and here's an example, that it would have, in 1968, leaving aside abortion, in 1968, it would have been unthinkable for the court to have said that states could not criminalize same-sex behavior. It would have been unthinkable, because that would have been outside the boundaries of sort of normal opinion in that regard. So, but within that, it depends a great deal on exactly who is appointed.
Here's a general question. What is Warren Burger's legacy as Chief Justice? I'm trying to capture it.
As Chief Justice, well, I think most people would say his legacy lies more in judicial administration than in his name on particular decisions. He was a great believer in modernizing the task of judicial administration. He created a number of institutions to help do that, the Federal Judicial Center, the National Center for State Courts. He was very interested in the state courts. And that's a meaningful legacy. Those are important institutions. Doctrinally, frankly, he was, you know, 1 vote of 9. A Chief Justice is 1 vote of 9. And he usually was aligned with the majority, partly for the reasons that we've just discussed. But there's no sort of, you know, Burger doctrine that I would identify with him.
I'm trying to think of, yes. I don't, no, I don't, to the extent that people Earl Warren was seen as a person who could actually lead the court. I don't think that people thought Warren Burger actually led the court.
Well, I mean, I'll mention actually one area that we haven't discussed, which was obscenity, which is Miller against California. So the court was just beside itself in the early Burger years over what to do with pornography, obscenity. There was not a coherent doctrine. You know, did a work have redeeming social value? Well, what did that mean? And the justices found themselves on kind of a weekly basis sitting in a basement screening room looking at dirty movies and trying to decide whether, you know, movie by movie it met some kind of test of obscenity. And it really was Burger who said, we've got to get a handle on this. Yes. This is not working. And Burger who said, you know, what strikes the people of you know, Podunk, Nowheresville, I forget what city he invoked, as obscene, doesn't mean that it's obscene in Las Vegas. And there's got to be a better way to do this. And we need to devolve the judgment to states and localities. And It was a struggle between Berger and Brennan because Brennan believed that under the First Amendment, basically, there was no such thing as obscenity and anything goes, and that wasn't going to fly. And the court, over months of struggle, crafted a new approach to obscenity where basically it's up to local control. And just speaking as a citizen, it seems to me that's worked pretty well, but at least it's kind of got the court out of the business of watching the movies. And and I think, at least my reading of the papers, the behind-the-scenes papers, and I write about it at some length in the book, that really was Berger. And I, personally, I'm happy to give him credit for it in any event.
Well, I can't resist telling my favorite story about the obscenity. I have a favorite story about obscenity, and it was that John Marshall Harlan, do you know the story? When he was the last couple of years that he was on the court, was blind. And so he had to have one of the other justices describe these movies to him. And he was this aristocratic northern guy, and he would nod and nod and nod. And occasionally he would say, "By George." So, and that's what I know about the constitutional doctrine.
I think we have time for one more question here. Was the Berger Court an activist court?
Well, judicial activism usually means the court's doing something that the speaker doesn't like. I'd say it was an activist court because it took what was given to it, a body of doctrine that it inherited, and it worked hard to change it. So that's a neutral definition of activism instead of just kind of stamping, each case as it came along. The court, I'll just say this, the court has virtually complete control over its docket. The Berger Court heard a lot of cases. They chose to hear about 150, 160 cases a year, which is more than twice what the current court does. And they selected cases that various justices thought would move the law in the direction they wanted to move it, and so on. And so, that was activist. But to me, that's not a badge of dishonor. It's just kind of a description.
I think I have a slightly different definition of activism, which is intervening, using the Constitution in particular to intervene against otherwise applicable rules. And I think in that sense, in one sense that we really haven't touched on, with the Berger Court was the beginning of modern conservative activism. And the three areas that I think about that are affirmative action, which everybody's aware of, campaign finance, and federalism. Even though it wasn't, you would describe it as making huge changes in any of those areas, that there was no conservative activism during the Warren era. So during the Berger era, we had that in the beginning.
Yeah, they knew where they wanted to go.
Yeah, there were at least, so the answer to the question is sometimes they were activists.
Excellent. Well, we'll have to leave it there. Linda, Earl, thank you so much for these great books. Thanks for this great discussion. Thank you, everyone, for coming. As a reminder, there'll be a book sale and signing down in the lobby, but thank you so much.
So I hope I'm not, it's when you say another 5 minutes.